कि आज के जो लेक्चर सीरीज है वो पहले नंबर है और क्रिमिनल पे हम लोग बहुत सारी बात करने वाले हैं। और आज के जो हमारे रिस्पेक्टेबल स्पीकर्स हैं बहुत ही नॉलेजेबल, और सभी आपको मैं जो पॉइंट्स हैं, बेसिक्स जो पॉइंट्स हैं सभी क्लियर होने वाले हैं। हाउ टू फाइल, वाई फाइल, और फाइल करते समय हमें क्रिमिनल पिटीशन फाइल करते समय किन किन बातों का ध्यान रखना है, वो सभी बिंदुओं पर हमारे जो आज के स्पीकर हैं वो प्रकाश डालेंगे। और मैं समझता हूँ और मुझे विश्वास भी है कि आप सभी लोगों को सारे पॉइंट्स क्लियर होंगे। इसी के साथ मैं वर्मा जी को रिक्वेस्ट करूंगा कि फर्दर प्रोसीडिंग चले। तालियों के साथ एक बार हमारे
वर्मा जी इससे पहले बोलेंगे, मैं आपको वर्मा जी का थोड़ा सा इंट्रोडक्शन दे देता हूँ। ये बड़े वर्सेटाइल काउंसिल है। ये आधा पैर इनका दिल्ली में होता है और आधा पैर इनका उड़ीसा और दूसरे स्टेट्स में होता है। आप कोई प्रोविजन ऑफ लॉ पूछ लीजिए, कोई स्पेशल एक्ट पूछ लीजिए किसी भी स्टेट का, राइट फ्रॉम मनी लॉन्ड्रिंग से लेकर के इन्वेस्टर डिपॉजिट से लेकर के यूनियन ऑफ इंडिया का कोल से लेकर के पीएमएलए से लेकर के यूएपीए से लेकर के, इस आदमी को सब कुछ आता है। उतनी नॉलेज मुझे भी नहीं। ही इज वन ऑफ द फाइनेस्ट ह्यूमन बीइंग, और इन पे एक्चुअली लॉर्ड जगन्नाथ की पूरी मेहरबानी। अब ये अपने बारे में बाकी बताना थे।
आज की कार्यक्रम हम लोग शुरू कर रहे हैं। के जी हमारे इस कार्यक्रम में अपने जो 4-5 लोग हैं, मैं अपनी रंजीता जी अभी आ रहे हैं अभी, और नजीम जी बार काउंसिल ऑफ इंडिया में कार्यक्रम में रह गए, तो अपनी इसी तरीके से, और साथ में सुधीर जी भी, हम लोगों ने कंसल्टेंसी रूम की जो एक लेक्चर सीरीज शुरू किया। आज 12वां लेक्चर सीरीज है। Today is the 12th lecture series on which our subject is on criminal revision petition. Criminal revision petition is filed before Delhi High Court with the tag CRL REBP. As everybody, all of us knows that this consultancy room lawyers lecture series is continuing on only the nomenclatures on which the Delhi High Court is to deal with the matters. So on criminal revision petition, we have certain areas in which we are dealing with in the criminal side. That is under section earlier 397, it is 438 BNSS, where there are certain interlocutory orders, or the orders which are being treated as those which can be reversible. In a revision only that is permissible under the law. So that is what the criminal revision is in Delhi High Court. What are those laws? In revision we have got either you can approach to the Sessions Court or you can come to the High Court. So in High Court, when we are dealing with the criminal revision, that is CRL REVP. When we are filing the CRL REVP, we require to have lot of, on starting from the drafting of the petitions till up to the arguments in these cases. So we have got the younger lawyers like Sai Teja is a counsel from Supreme Court also. We have another, the leading lawyer, young lawyer. He is not here, but he is Arun Demal because of his ill health, and he is also contesting the election. So that is the reason why he couldn't make it to reach today. But apart from that, we have got another moderate senior. We can say that the prominent senior lawyers among the younger generations is Gautam Das. He is also an advocate on record. He started his career from Patel House, then in Dwarka, but his primary focus is in the state of Odisha, is in the Supreme Court of India. So we will be also hearing Mr. Gautam Das. He has got a long-term practice in the criminal side. So apart from that, we are quite fortunate. One of the dynamic and young senior advocate of our Delhi High Court. From day one, I have seen him. Is kind of the beautiful presentation, we can say that. He used to argue his cases wherein we used to be quite, impressed upon his presentation also. He is Sanjeev Sagar ji. So we'll be hearing our, our friends. So we'll start with Mr. Sai Teja ji. Sai Teja will tell us regarding this criminal division petition. So I will request Mr. Sai Teja to take the mic.
Thank you, sir, for a beautiful evening. Ideas and experience of this revisionary jurisdiction under the criminal law. When I speak about the revisionary jurisdiction under the criminal law, the jurisdiction itself is very narrow and it needs to be exercised in a very meticulous manner. When I say what are the powers and what is the mentality of a revision, first of all, the important aspect of the revisionary jurisdiction is that to correct any perversity in the findings of the courts below, point number one. Point number two, if there is any irregularity in the conduct of the proceedings. Point number three, if there is any finding arrived where there is no evidence or the evidence itself is inadmissible. To cure such lacunas, to cure such defects, if there is any jurisdiction I can invoke, that is the revisionary jurisdiction. And this is not exhaustive. The grounds whichever I stated are not exhaustive per se. Now, there is a specific bar against which I cannot invoke the revisionary jurisdiction. That is in 397(2), which says that I cannot invoke the revisionary jurisdiction against an interlocutory order. Now I want to lay my points more on this aspect because there are other two speakers and there is
Completed.
right. So I would
See,
just
you take it as if now you are the judge who is giving judgment. We will sign it. I agree with my brother.
okay. So when it comes to interlocutory order, now there is much water has flown on this particular topic of mentality of revisionary and the bar as statute has provided. As I said, there is a specific explicit bar which says that a revision is not allowed against an interlocutory order. Now, to understand what is interlocutory order, we should understand the different types of orders that are possible. One is the final order, the second one being the intermediate order, and the third one being the interlocutory order. One is the final order, intermediate order, and third one being the interlocutory order. Now, a revision is maintainable on the point number 1, 2, but that is final order and intermediate, but not on the interlocutory order. Explain more on this part. Interlocutory order. Now, what is interlocutory order? To understand interlocutory order, let us try to understand what is final order first. Now, what is final order? If the order adjudicates the final rights of the litigating parties, then it is said to be a final order. Now, what is intermediate order? In the intermediate order, the rights of the litigating parties are not completely adjudicated qua the entire litigation, but only subset of the litigation. Then that is the intermediate order. And interlocutory order, there are no rights that get completely adjudicated, or there is no adjudication of rights whatsoever. And it will not have any final effect on the final order. Now, if any order which does not decide the finality or the subset, whatever I referred, then it is deemed to be interlocutory order. And based on, if I have to challenge that, I cannot invoke the revisionary jurisdiction. If it is a final order, if it is intermediate, I can definitely invoke the revisionary jurisdiction. This is one of the important points we need to consider before filing the revisional jurisdiction, because the maintainability issue comes the moment we file something. And we need to explain the honorable courts whether why it is maintainable first. Once this preliminary point is clear, then it is a matter of admission and then merits come into the play. Over a period of time, the interlocutory order definition or the way to define an interlocutory order has been touched upon and it was decided in many of the cases. Now there is one other important point I want to put in. Now there are few cases, the nomenclature shows to be a kind of interlocutory order. Nomenclature wise, it appears to be interlocutory order, but the rights are determined. Now, if I have to directly use 397(2), then my order I'll not be able to maintain it before the revisionary jurisdiction. But the rights are determined here. In that particular case, if there is a way we can explain the court, though the order appears to be interlocutory order, but it determines the rights. It determines the rights of my litigation, subset or the whole litigation. Then an interlocutory order can also be challenged under the revisionary jurisdiction. More precisely, subset of that. So I want to read out few lines from one judgment, then based on which the clarity will be, you can see the clarity with respect to the what is the interlocutory order and all that. So
one thing is clear from his that there are three kinds of orders. Please understand, the final order, intermediate order. Final and intermediate orders will decide fully or partially or a little substantially rights of the parties. So therefore, as per him, what the speaker is emphasizing, you have a right to revision. Though definitely against the final order there is an appeal also, after an appeal there is a revision also, similar is for the intermediate also. But he is explaining that once it lands in the trap, that which has the colors of interlocutory order. Now he will explain the interlocutory orders. Interlocutory orders will be in the nature of, now he will explain. I will take a pause for a moment.
thank you, sir. Now in the case of Amarnath versus State of Maharashtra, AIR 1977 SC 2185, in para 6, the meaning of the expression interlocutory order has been given by the Honorable Supreme Court as, it seems to us that the term interlocutory order in section 397(2) of the CRPC has been used in a restricted sense and not in any broad or artistic sense. It merely denotes orders of a purely interim or temporary nature which do not decide or touch the important rights or the liabilities of the parties. Any order which substantially affects the rights of the accused or decides certain rights of the parties cannot be said to be an interlocutory order, so as to bar a revision to High Court against that order, because that would be against the very object which formed the basis for insertion of this particular provision in section 397 of the 1973 Code. Thus, for the instance, orders summoning witnesses, adjourning cases, passing orders for bail, calling for reports and such other steps in the aid of the pending proceedings may no doubt amount to interlocutory orders, against which no revision would lie under section 397(2) of the CRPC. So now, as I said, an interlocutory order, if you have to challenge the interlocutory order, the remedy is not under the revision. Only the final orders or the nature of the intermediate nature can be challenged under revision. Now, if I don't have the revisionary jurisdiction, now can I invoke 482 is another question.
Here I will take a pause. What he explained was, what is an interlocutory order? He read the paragraph. From the reading of the paragraph, only two magical words come out: interim and temporary nature of the orders. So therefore, if an order which you see as a council, once you read the order, you will come to know if it is purely interim and temporary, then it becomes interlocutory. Once it becomes interlocutory, then there is a bar. So as a council, first thing you have to identify is the nature of the order. Once the nature of the order is clear to you, you know what remedy I have to take. Sorry,
That's right.
I interfere only
No, sir.
so that
Clarifying it.
when my turn comes, I am not required to do any kind of labor. So interim, temporary, or whatever wordings you may say, it is out of revision. Sorry, dismissed. Go.
What? Now, this is something which I told. That the preliminary check whether the nature of the order as served has clarified what type of order it is, whether it is intermediate or interim or final. Now, if it is of the nature final order, yes, revision lies. If it is of the intermediate, revision lies. Now, interestingly, though the order seems to be an interlocutory order, but there is determination of or adjudication of some rights in this interlocutory order. Can I invoke revision now? Is the question. Now, just by looking at 397(2) and the nomenclature of the order, my petition would not lie against this kind of order. But however, I said, if I can clarify why it is maintainable, I should be able to demonstrate that though it appears to be the interlocutory order, substantive rights qua subset of the litigation are determined. Then even in that case, an interlocutory order can be challenged.
Yes, absolutely.
So this is
whatever will touch the rights of the parties, or there is an adverse impact on the right of an accused, which even impacts the investigation, or any kind of impact. Supposingly, I push somebody. So till I am saying I am like this, I am not touching. If I push, something has happened. So with the stroke of the pen, if something happens to the right of the parties, then he is absolutely, you are in the driving seat, getting into the seat of a revision.
so. This is something which I want to talk about the interlocutory orders, the bar specific bar under 397, which is of very much importance. And now I pass on my turn to the.
No. It is your turn. You have to first explain. You are not complete. Please complete.
Please carry on.
Please carry on. Please.
Further.
Because unless you understand the concept, what is the distinction? How do you maintain a petition?
Yes.
Unless you find a good judge like me, everything is accepted.
I will further. Now, what are the examples of what constitutes to be an interlocutory order and what not? Now, I would like to give you the examples. Summoning witnesses, adjourning cases. Now there is an adjournment in a case. You want to challenge this now. Now, what is the nature of this order now? Adjournment has taken place. You want to challenge this adjournment. What remedy lies now? Please analyze this. This would be a practical test case for us now. There is an adjournment. You want to challenge this adjournment. What is the nature of this order now?
Is it
Are-
final, intermediate, or interlocutory?
Interlocutory. Why interlocutory? Are there any rights that are determined here? Therefore, it is an interlocutory.
And in the interlocutory, what is the nature? Interim or the temporary? Yes.
Temporary. Right. So, then this is not amenable to the revisionary. This is what I want to specify. Now, I want to challenge something, but there is a bar under 397.2. There is a bar under 397.2. Now, what is the other remedy I have to challenge this? I want to challenge an order, but 397.2 is coming in a way I will not be able to file 397 or the revision petition. The other way is to look for 482. Now, when I look for 482, 482 also has certain rigors in the ends of justice or preventing the abusing the process of the law. There are some rigors in the 3 rigors in the 482 jurisdiction. If I am not able to satisfy those 3 rigors, then 482 petition is also not. Then what is left for me? Then I have the remedy under 226 and 227. So this is how we try to filter out or to see the appropriate remedy to challenge an order step by step. See if 39 revision is maintainable. If it is revision is not maintainable, I will try to see 482. Even if 482 is not maintainable, I will have to opt for the Article 326 one.
Here, you still need to understand the dichotomy between 226 and 227. Under Article 226, there are writs. You know all kinds of writs you have. But under 227, High Court has a supervisory powers over the inferior courts or the courts below or the trial courts. As we say now, there is no inferior court. So whenever an order like adjournment or a temporary nature of a subordinate court or a trial court comes up, which can't be challenged in an appeal or in a revision, then 227 is always maintainable. Sometimes a composite petition is filed under 226 and 227. Now it depends on the intellect of the judge. The judge would ask you, Madam, how is 226 and 227 maintainable? You are coming against an order of a trial court. Why 226? Can there be a writ issued in such a matter? Answer me, can there be a writ issued in such a matter?
Yes, it is.
The writ can't be issued. The writ can't be issued. Under the supervisory jurisdiction only, the court will examine whether the adjournment was rightly given or wrongly given. There can't be a writ against an adjournment order. This is what he wanted to explain, and he's explained it rightly. But you, as a counsel, going step further, I have explained. 226, when it is to be used, there will be circumstances which he will explain when 226 is to be merged with 227.
Yes.
In generality, we were speaking about an adjournment order being a temporary. That is the reason I have explained.
One instance. Exactly. Now, when I say 226 is a high voltage line, I cannot touch it as whenever I please or whenever I like. Until and unless I demonstrate to the court that there is no other statutory remedy for me, I will not be able to touch it. If there is any alternative remedy, I cannot directly approach under 226. That is one important point that needs to be kept in mind. Now, this is with respect to the bar or maintainability as explicit in 397(2). Now, what are the other powers of the revision court? Can it appreciate the evidence? Appreciation of the evidence is normally taken care by the trial courts, and in the appellate courts also to an extent it is taken care of. But can appreciation of evidence be allowed in the revisionary jurisdiction? The appreciation or reappreciation of evidence in revisionary jurisdiction is not allowed. But, however, if the finding is arrived when there is no evidence at all, or when the admissibility or inadmissibility of that particular evidence comes as a question of law, as a matter of question of law, it can touch the evidence. but it cannot full-fledgedly appreciate or reappreciate the evidence as the trial court or the appellate court does it. At the same time, if the revisionary court feels that the matter, though it is filed under revision, it feels that there needs to be appreciation of evidence, then it has the power to convert the revision into the appeal. There is one judgment which said it can convert the revision into an appeal to decide the matter in the interest of the justice, because that is the objective of the entire law. That should not get defeated just because there is some bar, technically.
So I must clarify now under the BNSS, there is a specific provision in the 442 which is read before 438. The legislature has now codified itself, it can be converted. If you will all open the book, you'll come to know.
Could you please explain that 226 and 227 once again?
When my turn comes.
I think
See,
226 is the one.
when you watch a teaser or a trailer on YouTube, don't expect the entire movie.
Now my teaser is done, I will.
No. He's still in the item song. Please do it.
I'm glad, sir.
He will continue.
So now you can say the younger generation, how they are, well equipped with our entire, whether it is a, criminal revision petition, how it is to be drafted, how to start, and is no doubt being assisted, we can say that, guided by our senior friend of our. So without taking much time, so now we'll be going to Mr. Gautam Das.
Welcome back. Thank you, sir. Prashant, and all the friends. I'll start as immediately after the matter we had to rush. And when you address the lawyers, you know that they are already aware of some of the important aspect of the subject. I'll start with Dharma eva hato hanti dharmo rakshati rakshita. Now to start the revisional power and how we approach the High Court with the revision petitions. Revision embodies the duty of the higher courts to preserve legality, ensure fairness, procedural discipline and rule of law, a constitutional value flowing from fair trial jurisprudence. Now since the first speaker have touched upon the interlocutory order, I would now go for the intermediate orders. And I would definitely expect my senior friend to sometime to interject and to explain where I will fail.
Now see, I must clarify, my friend was excellent. He will be better than him, I believe so. And my interjection is not to correct them. My interjection is to supplement them.
Yes.
You must have seen Fast and Furious movie. Anybody has seen that? These are all those super racing cars. I am the nitrogen gas in that.
Now while Mr. Saiteja was explaining, I was just trying to look at those windows where I'll just try to cover some of the aspects. Like sometimes a lawyer, we think that when we are talking of the revisional power of a high court, we usually believe that it is to come from the appellate court, that is in sessions court. Sometimes the revision can also be filed straight away from a magisterial order also, if it covers the very process which is covered under revisional power. Now coming back to intermediate orders, in case of the interlocutory order, like my brother says, that procedural steps like adjournment, summoning of witnesses, those are barred, that you cannot come under the revisional power to the High Court. In intermediate orders, like those orders which decide substantial issues in the trial, is framing of charge. If the accused, while filing a 227 application for discharge, and the court proceed to frame the charges, and the accused, the petitioner feels that yes, this is a substantial issue whereby the court has proceeded to charge him under certain sections, then it can come under the revisional power. Also, in the case of refusing to discharge, in the similar issues when somebody has filed for discharge, if it is refused, in the jurisdictional ruling, revisable outcome affects continuations. When even if it is in the form of an immediate order, but deciding a substantial issue which affects the parties, the entire issue in trial, that can also be challenged by a revisional power. In cases of interlocutory order, the party to the suit or lease or the criminal proceedings, when somebody, a third person, affects by way of an interim order, can also challenge third party. If the third party is not participating in that criminal trial, like in a case of 319 CRPC, if we know that at a later stage also the prosecution, the complainant can also come up with an application to further aid those accused who stated to be or alleged to be involved in the offense. That can also be challenged, though it is a very, very areas where it is difficult
I will
at times.
explain. Supposingly, two persons fight with each other, and there is a complaint with the executive magistrate. The matter doesn't go to the metropolitan magistrate or the chief or the judicial magistrate. Now that is a trivial fight matter. There is an order of restraint passed by the SDM or the executive magistrate and all. All these kind of orders are passed, sometimes they take into sweep third parties also. I did a matter in Supreme Court where the people were fighting only on the Nali thing, which is the drain lane, and the Supreme Court said this Nali will become a big Nala, please stop fighting. The revision should have been allowed by the High Court. It should not have gone that they were not party, the third party is impacted. In all these kind of cases, the third party's revision will be maintainable before the High Court. And one more supplement I will say, even impleadment of parties is allowed. Supposingly these two parties are fighting and the judge comes to know that, see, there are third or fourth person who is also impacted. The High Court or the Session Court, while hearing the revision in such type of cases which are originating from trivial offences which are mostly before the executive magistrates and all, they implead parties also. So he is right. Many a times magistrates' orders are also there in the nature which impact third persons. If third party is impacted, definitely the revision at his behest, irrespective of intermediate, final, interlocutory, or will always be maintainable, because he is not a party to the case. If he is not party to the case, his rights can't be infringed, in not impacted, because whatever we have only rights. No, we are exercising rights. We are moving we are sitting here, moving in the corridors of the High Court. We have rights. If we go strictly by the IPC and all, 5% and more cannot stand together, it will be an unlawful assembly. But more than 5 or 10 lawyers are standing. So these are all rights.
Now, substantial right tests also is seen to identify the intermediate orders. Just to supplement my brother Tejaji, whether does it decide the legal or jurisprudential issues, jurisdictional issues, sorry, whether it affect liberty or legal status. Also, would the opposite view terminate the proceedings? In that case, if it is yes, then it is revisable. Despite the 397(2) bar, then the standards of review, where the revision lies, where there is patent illegality exists, then jurisdictional error, and also the finding are perverse and irrational. I will just, it is a supplement to that. In the case of revisional power, when we use from magisterial court's order to straightaway High Court, it is advised that once you opt for one court in a revisional jurisdiction petitions, you cannot again come in that. Even in case, if in your revision petition before the trial court, before the appellate court, that is sessions court, from a magisterial order, if it is dismissed, then you cannot also take the route of 482. If it is dismissed, if the revision is dismissed, you cannot come again through backdoor under 482 and seek the same relief. That is also not possible.
But there is a distinction and catch in this. Supposingly a maintenance order is challenged in the first revision by the husband. If the husband loses or wins, if husband wins, maintenance is reduced from supposedly 20,000 to 15,000. Then what is the remedy with the wife? Tell me. What is the remedy with the wife? What will wife do? Was the maintenance of 20,000 in first revision was reduced to 15,000. What is the remedy?
Wife will also file the revision petition.
Where? Well, that will be a second revision then.
Yes.
Will it be maintainable? Why?
They maintain it before the Supreme Court,
Why?
SLP.
Why not High Court? I said sessions only.
Because the Honorable High Court passed the order. So
No, sessions pass the order. Magistrate's order is 125 CRPC.
second revision lies before the High Court.
It will be a cross revision.
Second revision by the wife before the High Court will certainly be maintainable because she is now aggrieved. She was not in the first revision. So there are two kinds of revision: the first revision and the second revision. So wife will have the remedy to go to High Court. Wife will not go directly to Supreme Court because if this is a time and tested thing, many persons under the impression that after the first revision it would not be maintainable before the High Court, go to the Supreme Court. Supreme Court immediately says, why have you come here? Go to High Court. See, it is actually a cross revision, no? I hope my friends agree with me.
I believe it is because one party has already filed a revision. If the other party finds any revisional issue with her or him, they can also file a separate revision petition.
Husband having lost cannot file a second revision before the High Court. It is the cross because wife's rights are impacted because the magistrate's order was
Independent right.
changed. So it becomes an independent.
True.
Now, once we now have spoken about the revision, how we come about, what are the orders, interlocutory, final, and intermediate. Now, once we file it, the admission implies an arguable issue. Once the High Court or the Session Court in Magisterial Court's order, once the High Court admits it, then it requires an arguable issue, it is a must. Then once it is admitted, then the High Court, while deciding this revision, it has to be a speaking and reason order. It cannot be an order in limine. It has to be a speaking order. Then no dismissal for default after admissions. Even if the revision is admitted, the matter proceeded. For after some time, a lawyer for some reasons on the party, if they don't proceed with, the High Court just cannot dismiss it in limine. It has to pass a reason order. Then revisional court may also, now while my friend was saying that whether revisional court can take evidences, now on my preparations it says that revisional court may take additional evidence where law permits. I think that is an area where by way of different judgments, like he said this Amit Kapoor and the other one which brought in this 397-2, it says that it can also, but it has to be in that format where evidences are completely illegal. Then the ends of justice, not for delay. Now in question, we say that there are delays, the proceeding goes on. Why the intermediate order is consciously been barred is not to let the proceedings at the original court delay. For that, it is recommended. I think I end with this. My
Very good, excellent, and the part of Gautam Das ji. As you are finding that time and again different issues is being dealt with by us. Similarly, the criminal division petition, which is today's subject, that is CRL REVP. On CRL REVP, while discussing that, we are also again going to various read courts also. But at the same time, you see, when the order is passed, that is being challenged. Ultimately, you are looking into the areas wherein the evidence yet to come before the trial court in a in a criminal prosecution in those areas, what are those evidences which are there, whether those are required to be appreciated again, or whether they are being appreciated earlier, or that has never been dealt on a technical manner only, those matters are being dealt with. So it is not that all criminal revision petition the way we are arguing, those will be accepted. So because there is a case which is pending before your trial court, that is the prosecution's case. Prosecution has to bring the evidences before the court, and in those, whether these petitions can be an interference also, that is also required to be seen. Interlocutory order, ultimately it may be challenging or it may be deciding the ultimate decisions on that case. So therefore, the criminal revision petition has got a limited scope, and while whether it is in the sessions court or in high court. So all Teja has also dealt with, it is from the from the private client of view, or our friend Gautam Dasi. From the prosecution side also, you have to have also something into mind, that what the prosecution can also put their mind into these arguments, and they can also put it before the court. So we will be discussing further, enlightening us by our senior advocate Sanjeev Sagarji, who is very much clear on these issues, as we are finding from time and again. He is also giving us illustrations how they are trying to say or convey before us. So we will be hearing Mr. Sanjeev Sagarji, senior advocate.
First question, what was your question? 226, 227, 482? She rightly asked difference between 226 and 227. Now, as I explained, 227 is a supervisory jurisdiction of high courts over its subordinate courts. Now, this is a magical provision. You should know that, and these are all part of constitution. Every case is dealt in terms of a special act codified for that. Now CRPC now becomes BNSS, evidence becomes something else, then IPC becomes something else, but constitution always remains the same. Constitution is supreme. It has got all the powers. Article 226 and Article 32 deal with powers of High Court and Supreme Court to issue writs. Fundamentally, it is the Bible or Gita of the entire constitution when it comes to safeguarding the rights, entitlements, and other humanly benefits which are available for the citizens of India. That is the reason I said there are various writs go over onto certiorari. Certiorari means quashing of any order. Supposingly an order is passed, administrative order is passed, it can be quashed under Article 226. 227 it can't be quashed. How can it be quashed? Because it is a supervisory jurisdiction. Now, if it is a supervisory jurisdiction, whatever will originate and go to the High Court will only go from the orders passed by any of the court subordinate to it. Now, this subordination definition has increased without looking into the mobile by one of the persons who is sitting here. बोर लग रहा है सर? नहीं बोर लग रहा है? नहीं सॉरी सर प्लीज. ओके फ्लो टूट जाता है. Please. So, where was I? Supervisory jurisdiction under 227. Now 227 now gets expanded to tribunals also. Not the arbitral tribunal. Not at all. Arbitral tribunal is private, constituted by the parties. But all tribunals constituted under the acts. Supposingly, a tribunal is constituted, which is MCD tribunal, debt recovery tribunal, debt recovery appellate tribunal. Now we have debt TRI, TDSAT, then state commissions, for Consumer, National Commission for Consumer, all these earlier were not within the domain of 227. What happened was there were different kind of cases decided by the Supreme Court. The cases started piling up before Supreme Court. The Supreme Court then came with a decision that no, nothing doing. You go before the High Court and test this order under 227 because it is falling in the rigors which is not available under the revision. All these acts have only three things: complaint, complaint or petition, which we may call application, or then there is an appellate remedy, and then there is revisionary remedy. If it is not falling within the rigors, then 227 was made available. With a difference, when it came to Central Administrative Tribunal regarding the service law, then the matter started going to Supreme Court. The Supreme Court said, why come to me? Why are you bypassing your own High Court? Then a 226 remedy was given under to the High Court. Like in labor courts, again 226 remedies available when the award is sought to be quashed. Right? Then Article 226 and 226, the writ is filed. Similarly, against the Central Administrative Order, bench's order, Article 226 is filed, seeking a certiorari. Please quash it because this administrative order or this order is against me. But whenever is mostly it is originating from trial court, even a civil case, an order which can't be challenged in an appeal, it can't be challenged in a revision, it cannot be reviewed, then at the end of the day, this is impacting the right of the parties. Maybe it is intermediary, maybe it is interlocutory, but it is not a final order. It has a serious impact on the list also. Then 227, the court interferes. So this is the difference between 227 and 226, which every council needs to understand before going to the court. I have also filed many. When I joined this profession in 1998, my seniors were filing composite writs under 226 and 227. One day I asked my senior only, sir, why use both of them? No, you do not know. It is a culture now to file 226 and 227 because at that point of time the number of courts were less and the judges were also very liberal. They were not at all technical. Rarely and seldom anybody had read the entire title of the case. They always used to read the prayer. In the prayer, nobody I have ever seen write, I pray kindly grant a writ under Article 226 and also exercise your supervisory jurisdiction under 227, thereby quashing this order and grant me relief so and so. Every prayer is like this, declare this, under the circumstances grant me this. I hope you agree with me. So that changed the game. Now coming back to the criminal jurisdiction aspect of it, one should understand before the sessions called, we have only one section. Earlier it was 397, I believe now it is 438. Yes. 438 says simply whatever is available to High Court is available to the Sessions Court. But Sessions power are limited. Session is not High Court, so it will never have 482. Session will never have 227. So getting a revision admitted or decided on the maintainability before the Session Court becomes more tedious and even very difficult. Because it doesn't have anything else other than that. But when it comes to High Court, there are judgments to that effect. That if there is a petition under 397 which happened 42 now, and a relief cannot be granted in that, then the High Court should not be reluctant in using 482 or 227 or even 226 to grant relief in such a matter which is actually an abuse of process of law. Eventually, revision is itself based on patent error, perversity in the order, patently illegal, abuse of process of law. These aspects are to be seen like no evidence, and still this a person is suffering at the hands of the order of the trial court or the appellate court or whatever. These all aspects are to be seen when you file a revision. It is the counsel who decides by his own reading that what is the nature of the order. Once you get to know the nature of the order, you get to know the crux of the matter, and you get to know whether I have to file an appeal or revision, or if both of them are not maintainable, then 482. If 482 is not maintainable, then I will file a writ or I will file a petition simpliciter under 227. I give an example. Supposingly somebody comes to take possession of your house under the provisions of the SARFAESI Act. Now, section 14 of the SARFAESI Act says CMM shall have the power to appoint a receiver in favor of the bank so that they take possession. Initially, when the law was not developed, everybody was challenging the CMM's order. Because under the CMM's order, under the SARFAESI Act is not a criminal act. Everybody was filing petition under 227, under the supervisory jurisdiction, saying that this order is infringing my right to shelter is being infringed, so therefore, under 227, this order has been is wrong for such and such reason. The authorized officer of the bank has not produced this document. This document has been concealed. The compliances of these provisions were not made. So under 227, they started challenging. Then the matter went to the Supreme Court. The Supreme Court said nothing doing. There will be no challenge to this order, no revision, no 227. If anybody is aggrieved, go to DRT and file a petition for taking any kind of interim measures or final decision on the steps taken by them. Similar kind of situations you will find in all the special acts. All the special acts. But one thing you have to keep in mind, when a revision is placed before any of the judge, he doesn't enjoy powers of the original trial court or the original appellate court. Because trial appeal is a continuation of the original trial. Revision is not a continuation of original trial. It is purely discretionary in the supervisory jurisdiction. I may agree or I may not agree. Many a times I find that judges, being human, are kind to the accused by using their revisionary powers like a divine intervention of the God, and in those cases where there are no reliefs, the judges use revision and grant relief. Like recently, Justice Manmohan had passed a judgment regarding 138 cases. I hope everybody must have read compounding of cases. Normally what happens is a trial happens, you go in appeal, appeal there is, the sentence is confirmed, the compensation is confirmed, then one goes to the revision only if you are able to show patent illegality. If you cannot show patent illegality, then what remains? Then the court says these are monetary issues. There should be a right of compounding by way of payment of some kind of compensation to the person, even at the appellate stage, the trial stage, at the revisionary stage. So the Supreme Court beautifully explained. I will actually ask you all to read Justice Manmohan's latest judgment. You will get to know the powers of the court at all stages. Then again, distinction between 226, 227 and 482 and revision. Revision comes with a rider. Revision comes with a rider. It says, I am available only for limited purposes. I will not do this. I will not do that. And I will dismiss you. Not entertaining at all. But 226, 227, 482, my discretion. I am the session judge. I am the High Court judge. I am happy. You have made out a good case. And your day is today very good. I will grant you relief. This is the actually thing which is always brewing in the judge's mind, that how can I help this person? And helping the accused, under all circumstances, every judge thinks like that. Maybe many a times when you appear, you feel that this judge was not with me. That day, the judge was always with you. The counsel was always with that day. the timing of that accused or petitioner was not good. Because what happens is next time when you go, the situation and the table turns. The judge is well read. He said, okay, I have read your file. Today you will get the relief. My experience, I must tell you, when I joined this profession, I got a matter for criminal revision with great difficulty. One of the first matters, it was a DTC bus driver's case. Now that DTC bus driver's family came to me, सर बचा लो, हमारे पति को बचा लो, जेल में सड़ गए, इन्होंने बस से किसी स्कूटर वाले को मार दिया था, मेरे पति को बचा लो. The counsel who had come to me with a brief, he said, सर 2000 रुपए मिलेंगे एक हेयरिंग के, आप इन्हें बचा लो. I just asked them who is against me. He said, टीपी बहुत इजी है मैडम, आप हैंडल कर लोगे सर. मैं क्या, कौन है? मुक्ता गुप्ता मैडम. मैंने कहा गई बहस मार. But as the fortune favors the brave, this was a case where trial he was sentenced, appeal he was sentenced, first revision he had lost. In a fluke we filed second revision. Because the first revision was also dismissed by High Court. We filed it before the Justice Agarwal was there. He asked me, young man, how is this maintainable? I said, sir, that I don't know. But I only know that this poor man has already languished in jail for almost 1.5 years. He's just a DTC driver. You know how scooter drivers drive. He was Lehrao fine before the bus, and bus was not able to apply brake. He said, thank you, young man. Sentence undergone, he is released. Yes. So, it is all your timing that how you make things maintainable. Everything will sell, provided you know how to sell it. You should know that. I was asking my friend Sanjay Sharma sir that can you enlighten me about revision and all. He said if you want to understand the concept of revision, revision was always available with the kings in the ancient times. He knows the law in detail, and he can, if you sit with him, he will tell you each and every detailed aspect of this. He will tell you what was there in the ancient times, then what was there in the British time, and then how this law was developed and why this law was developed. Revision normally is always the best after the final order. At even intermediate stage, getting an order in a revision is just like getting the goat out of the lion's head. But after the final order, the appellate court's order, the court is also a little lenient towards. At that stage, my friend said, sometimes evidence is also taken, extra evidence or some kind of circumstantial evidence. But normally it is always taken by the Supreme Court only because they have powers. High Court doesn't have powers. Supreme Court under Article 142 has supreme powers. They look into this. But it is not at all available with the High Court. But still High Court, in order to do substantial justice, I have seen my High Court, I have seen other High Courts also. There are brilliant judges. Now we have Justice Katwalia, we had Justice Sodhi at one point of time. These oldies, some must be knowing. Justice R.S. Sodhi was a person who would go from Kashmir to Kanyakumari to give you relief. But if you will tell false or lie things before him, he will take away your relief even you are sitting in Europe. Vasanta ji knows it very well.
In arbitration, second appeal is not maintainable.
Arbitration, where is the question of second appeal?
So, whether it is maintainable will become...
No arbitration, no. Arbitration, sir, Only section 34,
34, 37.
and then 37 and 36 is execution.
In my 37 article is dismissed.
Yes.
And there is SLP, we can only file SLP.
Come here, I will dismiss that.
We are going beyond the scope of today's lecture.
That is the reason I said, come here, I will dismiss that.
I can file rate under 2 to 7.
Sir, your meter starts now. I am charging 55,000 rupees per minute. No, out of the syllabus question. You are like a professor who has prepared question paper, and I as a student say, मम्मी सब आता था लेकिन question ही out of syllabus आए.
Criminal revision petition में question आता है मतलब
See, I hope the concept and those who have come late, they are all welcome. You missed the bus. We will try to give you some kind of flight, but the flight will also be very short. Not, we can't take you to Chandigarh or even Jaipur. Time is very less. So it is purely judicial discretion. Now you should also know one thing. While deciding to file a revision, you have to convince the judge.
yes.
Convincing the judge is the most important aspect for every counsel. How you start. And then in English we say active tone and passive tone. Can anybody tell me what is the difference between active tone and passive tone? एक्टिव टोन वो हुआ जैसे लट मार मैंने बोल दिया, हाँ भाई कर रहा है कि नहीं कर रहा है. पैसिव टोन ये हुआ कि जहाँ पना अगर आप मुझे माफी दें तो कुछ इल्तजा करूं. दैट इज अ पैसिव टोन, saying one thing in a two different manner. So therefore when you go to the court, the conversation always starts in an active tone. Yes, what is there in the matter? You try to, no, my lord, listen. No, I don't agree. Then you will have to switch over to your passive tone. See, you are right, I am right, but there are different limbs to being right. If I am right for this, and if you will understand this, give me a chance, maybe I demonstrate and explain. Then the judge will say, yes, you tell me. I agree. You have to impress. The first thing which a counsel needs to understand is how to impress the judge. Like in college, the boys have to impress somebody else, the girls have to impress someone else, and at home, our parents emphasize that relatives are coming, you have to impress. That's their fix.
Anyways, Valentine's Day is coming very close.
Valentine's Day is coming, he is getting ready. He is getting ready because of his age, he can get many Valentines. I can only be a sugar daddy. So, coming to that revision aspect they have explained, and I have also explained the power of a counsel. The power of the counsel is the most important aspect in any kind of matter. It is the counsel who can make the brief, it is the counsel who can demolish it. Do your homework. Once you do your homework, once you know what is the nature of the order, once you identify the three limbs which he has explained, final, intermediate, interlocutory, then you have to again understand, divide that interlocutory. The interlocutory in the judgment is always written like interim and temporary, but there is a third limb also. That is the third eye of the counsel. What he digs deep and comes to a conclusion that no, this is not an interim or a temporary. There is something else which is actually touching the rights of the parties. Once he comes to that, then he is in the right. And he is not required to lose at that point of time. He, hook or crook, he has to get into the bus. Once he gets into the bus, then if a revision is admitted before the High Court, even though there is no stay, the trial court itself restrains. It goes into the slow mode. Let High Court decide. Why should I be in a hurry? I will decide those matters in which there is no interference by the High Court. Then, like he says, adjournment orders and all are not revisable. You will have to identify what is the impact of the order.